Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Robertson, Court of Appeal for Ontario. Heard July 3rd, 2020 by video conference. On appeal from the sentence imposed by Justice Joanne LaFrance Cardinal of the Superior Court of Justice dated April 18th, 2019. Reasons for decision. Between September 30th and November 6th, 2018, the appellant went on a drug-fueled rampage in Cornwall, Ontario, which included breaking and entering and robbery of 10 establishments, ranging from chip stands and food trucks to a convenience store to Pet Value, a larger commercial establishment. He pled guilty to 2 counts of robbery, 8 counts of breaking and entering, attempted break and enter, dangerous operation of a motor vehicle, failure to comply with a probation order, 2 counts of failure to comply with a recognizance, possession of a break-in instrument, and disguise with intent. Consistent with the joint submissions of the Crown and Counsel for the appellant at the sentencing hearing as to the length of imprisonment, the sentencing judge imposed a global sentence of 4 1/2 years imprisonment. She also made orders under Section 738 sub 1 sub A of the Criminal Code, which require the appellant to pay restitution in the total amount of $15,698.34 to some of the persons whose property he damaged. The appellant argues that the sentencing judge erred by failing to consider whether the appellant had the ability to make restitution before imposing orders under Section 738 sub 1 sub A, and that the orders under Section 738 sub 1 sub A will likely impair his chances of rehabilitation. He submits that the restitution orders should be set aside. We agree. A restitution order forms part of a sentence. It is entitled to deference, and an appellate court will interfere with the sentencing judge's exercise of discretion only if there is an error in principle, or if the order is excessive or inadequate. An order for compensation should be made with restraint and caution. While the offender's ability to make restitution is not a precondition to the making of a restitution order, it is an important factor that must be considered before a restitution order is imposed. A restitution order made by a sentencing judge survives any bankruptcy of the offender. This means it is there for life. A restitution order is not intended to undermine the offender's prospects for rehabilitation. This is why courts must consider ability to pay before imposing such an order. It is not enough for the sentencing judge to merely refer to or be aware of an offender's inability to pay. The sentencing judge must weigh and consider this. The restitution orders were not part of the parties' joint submission on sentence. The Crown handed up a table of the damages suffered by the various establishments, and a single sentence asked for standalone orders. In response, counsel for the appellant at the sentencing hearing submitted, quote, "Just with respect to the restitution, I'll ask, if the court is going to impose restitution, it would be 738 orders, given that he's not going to be in any position to pay any restitution for the next few years," end quote. While the sentencing judge's reasons explain how she calculated the amount of the restitution orders, and she did so carefully, they did not contain any analysis of the appellant's ability to make restitution, or of the impact of the orders on his prospects for rehabilitation. During the appellant's counsel's sentencing submissions, the sentencing judge inquired whether the appellant had ever worked. Respectfully, however, she did not conduct a meaningful inquiry into the appellant's ability to pay and the impact of the restitution orders on the appellant's prospects for rehabilitation. In failing to do so, she erred in principle. The sentencing judge was faced with an offender who, at the time of sentencing, was 32 years of age. He has a grade 12 education. The appellant reported that he had held a job in the restaurant industry for a decade steady in his 20s. the appellant had also worked out west in the pipelines. Whatever his employment history, at the time of the offenses, the appellant was unemployed and seriously addicted to cocaine and opiates. The aggregate amount of the restitution order is significant to someone in the appellant's circumstances. On release, the appellant will continue to have to battle his addictions as he seeks to become a productive member of society and provide support to his young daughter, and he will do so without the benefit of higher education and hampered by a criminal record. As the sentencing judge noted, the appellant had a lengthy criminal record for a person of his age. However, before these offenses, the longest period the appellant had served was 119 days of pre-trial custody. The period in custody for these offenses will hopefully have provided the appellant with the ability to obtain treatment for his addictions and put him on the road to rehabilitation. In our view, the restitution orders made undermine the prospects for that rehabilitation. Accordingly, the appeal is allowed and the restitution orders are set aside. Appeal Justice Alexandra Hoy, Appeal Justice J.C. McPherson, and Appeal Justice M. Tulloch.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.